Hi, everyone. I'm Sean Salmon, the Vice President of MCLE and Professional Development here at Quimbee. Joining me today is retired civil rights attorney Sam Cohen. Sam is based in New York and over his career has successfully represented numerous prominent activists, groups, and journalists in a wide variety of legal proceedings. Today, Sam will be chatting with me about the 14th Amendment, and our conversation will cover equal protection, due process, and more. So I think without further ado, Sam, let's get started. I think where I would like to start today is just tell me a little bit about the 14th Amendment, specifically some of the language.
Hi, Sean. Thank you so much. And thank you so much to everyone at Quimbee. So let's get into it. We're going to be focusing today on really the first section of the 14th Amendment, which if you look at the text, it's actually rather lengthy. But the first section is just that all persons born or naturalized in the United States and subject to the jurisdiction thereof are citizens of the United States and of the state wherein they reside. That's part of it. And that in and of itself gives us birthright citizenship, which is a hot issue. No state shall make or enforce any law which shall abridge the privileges or immunities of citizens of the United States, nor shall any state deprive any person of life, liberty, or property without due process of law, nor deny to any person within its jurisdiction the equal protection of the laws. So we've got both due process and equal protection there, as well as this birthright citizenship.
Right. So, and just like, let's remind me a little bit, like, wasn't there already a due process clause in the Fifth Amendment?
There was already a due process clause in the Fifth Amendment. The Fifth Amendment, which deals with self-incrimination, among other things, does note that no person shall be deprived of life, liberty, or property without due process of law. So that sort of raises the question of why did the framers of the 14th Amendment feel that they needed to put in another due process clause to a constitution that already had one? And there are really two answers to that. The first one, the big one, and something that we'll be talking about a lot today, is incorporation of rights. And so incorporation is something you may remember from con law. It is the guarantee of constitutional rights, usually rights from the Bill of Rights, the first 10 amendments, against intrusion by state governments as well as by the federal government. And this was something that prior to the 14th Amendment and really prior to the Civil War was a very unsettled piece of law in the United States, whether the rights guaranteed under the Bill of Rights were simply restrictions upon the federal government or upon the states as well. And the 14th Amendment was intended to resolve that. And as we'll see, it didn't resolve it quite as smoothly as the framers intended. The other answer as to why we have a second due process clause in the 14th Amendment is later on in the 14th Amendment, in Section 5 of the 14th Amendment, which notes that the Congress shall have the power to enforce by appropriate legislation the provisions of this article. So this is an enabling clause for constitutional rights enforcement, which raises a question: how does one make legislation to enforce constitutional rights? And we'll be getting into that in just a few moments. But strangely, the answer is rather similar to the way that currently in Texas, Texas is attempting to limit abortion protections under their state Senate Bill 8, which gives a private right of action to people who can bring suits against people who they believe are performing abortions in violations of the law. The way that Texas does it has a bit of a bounty hunter flavor, but what Section 5 of the 14th Amendment allows for, besides federal legislation that places limits on state power, is also the rise of what we now refer to as private attorney general statutes, where people have a private right of action that they can take up in order to induce the government to act according to its guarantees. So, yeah.
And just out of curiosity, I mean, can you talk a little bit more about how they actually legislate in a way to enforce constitutional rights?
Sure, yeah. So this was something that got started immediately during the Reconstruction period because it was necessary to create enforcement mechanisms for the rights that were extended to newly freed slaves, among others, and other disadvantaged people. And so essentially making states and making governments follow those rules was an immediate priority. And it was something that was done through what were called force acts at the time. And the third Force Act, which is also referred to as the Civil Rights Act of 1871, is the precursor to our modern statute 42 USC 1983, which currently provides a private right of action for individuals whose constitutional rights have been violated by state actors or government actors.